All right, we will call the Senate Judiciary Committee to order, and I'll ask our esteemed secretary to please take the roll.
Senator Harris, Senator Dondale Luke, Senator Orenshaw, here. Senator Nguyen, here. Senator Hansen, here. Senator Krasner, here. Senator Stone, here. Chair Scheibel.
Here, thank you so much. Please mark those senators who are not here yet present when they do arrive. We have two bill hearings on our agenda for today, and I believe they are both being presented by the same person, so unless you want me to go out of order, I will start with the bill hearing on SB 55. I thank you. Welcome back to our committee, and please begin whenever you're ready.
Thank you, Chair. For the record, John McCormick, Assistant Court Administrator at the Nevada Supreme Court. Last name is McCormick. And with me today at Grant Sawyer in Las Vegas is Judge Melissa Zaragoza to also speak about Senate Bill 55. Senate Bill 55 is, and this is dangerous when I say it, somewhat of a cleanup bill. There are some provisions regarding limited jurisdiction courts, particularly justice courts, that are a little antiquated. So I can go briefly through the sections of the bill, and then I believe Judge Zaragoza is available to answer questions. Section 1 of the bill conforms the statute regarding when a justice court can be open with the statute regarding when a district court can be open, and there has been some confusion about this section. However, it does not preclude a court from operating 24/7 for bail hearings, protection order applications, those type of thing. It just conforms the statute with what exists for district court. Section 2 of the bill modernizes the language regarding court clerks and changes some language to say the justice court instead of the justice of the peace to more accurately reflect current practice. Section 3 modifies fees related to searching physical and electronic records and implements a redaction fee. And also I did submit an amendment, I believe yesterday, on this that would actually conform the fees in district court as well. So they're the same across district and justice court, district court fees being in Chapter 19 and justice court fees being in 4.060. We have received some feedback on the fees, and we're obviously eager to work with anyone who has concerns on this issue. Section 4 modernizes the language surrounding appointment of the clerk of the court and the court administrator, and again, that's a modernization piece. Section 5 modifies the justice court jurisdiction statute to remove the ability of the Nevada Highway Patrol to file tickets into adjacent jurisdictions, so the ticket would need to be filed into the jurisdiction where the offense occurred. I don't necessarily know the genesis of that original statutory provision. However, I think at this point, it's no longer particularly necessary based upon electronic communication. The civil traffic system that the AOC has implemented to go with, obviously, the move to civil traffic in the state. Section 6 allows a criminal case to be transferred to another justice court if all the justices of the peace in a specific jurisdiction have been disqualified or had to recuse. So it just allows for the more efficient transfer. Rather than bringing a judge in, it can be transferred to a different jurisdiction. Section 7 conforms the language with some of the modernization that occurs in sections 2 and 4. Section 8 sets forth the rate at which community service must be credited against fines and fees to be not less than the state minimum wage without health insurance. Currently, the statute reads it's $10 or that rate. However, in discussions with the bench, it made more sense to make that the floor, and then as a floor, then courts can actually award more credit for community service in the event that, the market conditions, for lack of a better term, in the community dictate that. Sections 9, 10, 11, and 12 also conform sort of the language modernization with that in sections 2, 4, and 7. And then Section 13 repeals 2 outdated statutes regarding successors in office. for justice of the peace. Now vacancies are handled. If there's a vacancy in office, the county commission for the county appoints the replacement JP. So these are pretty antiquated provisions that are no longer necessary. That is a quick overview of the bill, and I will turn it over to Judge Zaragoza.
With your permission, Chair Scheibel, may I proceed?
Please go ahead.
Thank you. And Chair Scheibel, members of the Senate Judiciary Committee, thank you for having me. I am Judge Melissa Zaragoza with the Las Vegas Justice Court. I won't go through each section, but I wanted to add a little bit more information about some of the sections to put them in perspective. With respect to Section 3, there are some fees that we are adding in here, kind of addressing. And one of the awkward things about this particular section, the existing Section O, was that it had this vision of an old clerk's office where, you know, each box would contain a year's worth of cases, and for every year that you were searching for something, you'd charge a certain amount. Well, in today's age, while many of our courts still use paper files, many of our courts, especially the Las Vegas Justice Court, all of our files are electronic. So there is no searching for a year, and so to try to kind of equate that to how we would properly be charging a customer didn't make sense. So we changed it to allow for searching of physical records for those courts that do, especially our rural courts that don't have an electronic system. And then we added on, when you're searching an electronic system, just whatever term you're searching, we'd charge it that way instead of per year. The second part is the redaction. And I kind of wanted to put a little color on this. The Las Vegas Justice Court alone, over the past 2 years, I've looked at 2 specific calendar years, we receive over 1,000 requests for documents. Everything that we file into the court, we know our police reports and things like that are part of our probable cause packages. We need to review those, and we need to review them in full. So originally they are shielded, if you will, from anyone just coming in and seeing them online. But for those that request them, because we are a public court, we do have certain obligations to redact them. The majority of those 1,000 requests a year come from media. And when the media requests those, we have to go through. We have no individualized identified staff for this purpose, but it takes about 30 to 45 minutes for a staff member to conduct the redactions that are necessary. And that includes everything from complying with Marcy's Law for victim names, from personal identifying information and other statutorily required redactions. So it takes quite a while. And then a second part of that process is we have our staff attorney do a final review to make sure nothing was missed and make sure that it complies. If we just count the staff time, not even the attorney time to do the review, they spend nearly 500 to 750 hours a year, which is the equivalent of about 19 weeks of full-time employment or 6 months worth of work. And these staff members are not, that's not their sole job. I mean, they're there doing other administrative work, and this is just a part of it. So the number, we're just hoping, in part, because in our fee structure, the Justice Court keeps 25% of civil filing fees, and we are authorized to use that 25% for staff. So if we are able to charge for this redaction process that is quite costly, we would be able to use those funds to supply the employee that needs to do that work. So I just kind of want to put a picture on why we asked for that. Section 4, with respect to the, this is really the clerk of the court language, and it's always been the question. I've been asking for years. I've asked with our county counsel, who is the clerk of the Las Vegas Justice Court? Surprisingly, the statutes don't say. We don't have any statutory provision that says who the clerk of the court is. Instead, when we used to be combined, when the county clerk was kind of overseeing the clerk's office for the courts, when that separated, I believe this statute was just never updated. I don't know that. That's kind of my speculation as to how it came to be, because the statutes only refer to a deputy clerk with no clerk of the court. So this statute provides that the clerk of the court would be appointed by the justices in most circumstances, and in our court, that will become the court administrator. Currently, the current practice of our court has been that it's the chief judge. So our clerk of the court has changed every 2 years or every time there's a new chief judge. And it really should not be a judicial officer. It should be an administrative position. So that was kind of the genesis of Section 4. And for our purposes, instead of having a singular deputy clerk, which is kind of what the statutory scheme envisions, which is why we're striking that deputy language, all of our clerks, all of our records clerks, all of our courtroom clerks are considered deputy clerks, and they are empowered to issue summons, to issue writs, to do all of those clerical things that a clerk should do, and not just because they have a limited singular title of deputy, a specific person of a deputy clerk, but all of our clerks should be considered our deputy clerks and have that authority. Little bit about Section 6. While you wouldn't think that it happens that often, I will tell you that in my tenure as chief judge over the past 2 years, it came up probably 3 or 4 occasions. I had to consult the administrative office of the courts, the Supreme Court. I also had to consult judicial discipline because we didn't know what to do with a case when, say, a judge was a victim of a criminal offense or a family member of a judge, and everyone on the bench felt that we shouldn't be ruling on a case where one of our own is named as a witness or a party or a victim in the case. Yet there was no statutory authority for us to transfer that case anywhere. What we had been doing is finding a senior justice of the peace who would then be assigned that one particular case and have to come in to handle that one particular case each and every time. That just didn't seem to be the most efficient means when we have the ability to transfer jurisdiction to another adjoining township within our county. So that is the genesis of 6. Section 8 with respect to the community service. So obviously we are authorized to do community service. What we were doing in the past when the minimum wage was $10 is if someone had a $250 fine, they could work that off by doing 25 hours of community service work. That was very convenient, correlation between the money and the hours. Now that it has been raised to a non-even number. We had intended, the Las Vegas Justice Court, to raise that to 15. And then when the statute was changed to increase minimum wage to, it's not an even number, so it's not evenly dividable by a fine, we were unable to do that. So that's why we are asking for it to be converted so that that minimum wage is the floor, and then each individual court can kind of make that a number that fits nicely into conversion to community service. So no one has to do 24.75 hours of community service work to work off their fine. The final comment that I will make, and then I'm happy to answer any questions, is with respect to sections 13, the repealed or proposed repealed sections. These sections just seemed very odd and out of place. The 4.150 already covers what happens when there's a vacancy in office and provides that authority to the county commission to decide whether they will appoint or have a special election, and it directs them specifically to NRS 245-170 as to how to go about filling a vacancy. We've always been following that practice, no matter the source or the cause of the vacancy, whether that's by resignation or retirement or otherwise. So 4.290 and 4.300 just didn't seem to be necessary and seem to be redundant of the practice that's followed for a vacancy. And with that, I hope to answer any questions.
All right. Thank you so much both for that presentation. Members, do you have questions? Senator Nguyen.
Thank you for that presentation. I have a couple of questions about the Section 3, the fees and the addition of some of these. And I was wondering if someone could just explain to me what this means in real time or in real life, because it's a little confusing. Because I see in subsection O, it says, for searching physical files or records or files for each year, it's only $1. But then in the new section P, it says for searching in an electronic case management system for each search term, it's $5.
I think we're getting feedback because the microphone's still on in Las Vegas.
I'm sorry. I'll turn mine off so I can answer.
So I guess that's my question there. And even for the redacting, I realize that could be time consuming, but it seems, I don't know, maybe I'm missing something in what this actually means, but it seems like redacting is like $1 and searching records for a year is $1, but each search term is $5. So if someone can maybe explain that to me, what that means?
Yes, Senator Nguyen, thank you. I think when you're looking at the physical records, when people are coming in and saying, okay, I want to look for a specific case, that might be easy to find when you have a specific case number and you know what it is and where to look. With the physical records, the way it's always been was for searching records or files in his or her office for each year, which obviously the judges don't keep the records in their offices, so we struck that portion. But it already existed 1 year, so we weren't, or $1, so we weren't trying to change or increase the fee. Just try to make it more within reality within those courts that actually store their records. Some of us store our records off site, and when we do have paper files, we do have some older paper files that are being destroyed as the records retention policy brings them up. But in order for us to do that, we have to bring those records from an off-site location. The more items we have to bring and pay the company to bring them over is, I guess, part of that for the 1 year. For each year, I should say. I don't know how each and every court in our state stores their records, but we were trying to kind of keep that intact as the legislature intended it previously, and that was for physical files. The electronic, I'm happy to work with whatever amount. We had to come up with something, I suppose. When you're searching electronic records, it makes a big difference when names are spelled wrong. People are looking for files and they have a wrong spelled name. It makes a difference when you're looking for something for, like, say, an eviction or something like that, where you're searching by address. So there's a bunch of different ways to search, but it's not always that easy to find. The easy to find ones are great. Those that take a little more digging could take quite an amount of time. So I'm certainly happy to make that amount. We put an amount in there for purposes of putting this bill forward, and whatever the legislature thinks is appropriate is fine.
May I follow up, Chair? I mean, I'm sorry if I have a look of just utter, like, wild shock about that. I mean, it seems wild that if you had someone come in there and they didn't know how to, like, spell my name, and it would potentially, just to get, like, a case search with my name, if you misspelled my name 6 times, you're up to $30. I know that most of us will sit here on our phone and rely on, like, spell check, and if you didn't have spell check on the search engine that was on there, would be charged, like, $100 to search, like, one name. And especially if we're talking about people that are in an eviction proceeding or they already are indigent. I'm also concerned about, like, would private attorneys that are doing this as a part of their business, every time they went to go look up, like, someone's name and they didn't have an exact spelling of it, would they be charged like $5, $10, $15, $20, $30, $100 to search up records? I don't even know what the number would be that I would feel comfortable with. I don't even think if it was set at a cent, I might have issues with it too. So I really have concerns with that. So I'll just leave that there as more of a comment.
I would add one thing, if I may, Senator Nguyen, in responses. I think probably what this was more intended for is not that scenario where there'd be a spelling question. But when you have these groups that come in and they want to search the records, they want to search for, a bunch of different names. So they want to come in and they want to know, okay, every member on the, whatever, let's just say the Senate Judiciary Committee, and they might come in and say, we want to know on each one of them, we want you to run and tell us whether they have any traffic cases. And, we're running. So they're sitting there running name after name after name after name after name. And I think that's really more what that was intended to be, because it's a different search for a different person. And maybe we can work with that language to make that clearer so that it's a flat fee for searching for a specific case, if you will, or a specific person, rather than the name spelling, because I don't disagree with you at all on that. That doesn't make sense. So I appreciate you pointing that out. Thank you.
All right, other questions? Senator Krasner.
Thank you, Chair Scheibel. Thank you for your presentation. I was just wondering about Section 1 of the bill, where it says that no court may be open or transact any judicial business. Could this have any effect on bail hearings or any other type of hearings? I know in this committee, we've heard about people in this smaller rural town that might get arrested on a Friday, and then they're stuck there Friday, Saturday, Sunday. If there's a holiday, they're stuck there Monday. And so I just want to make sure that's not going to happen. Thank you.
Thank you for the question. John McCormick for the record. In that Section 1, there are there's in the existing statute, it's except for following purposes. And so the C there includes for the exercise of the power of a magistrate in a criminal action or a proceeding of a criminal nature. So those proceedings, so a bail hearing then is exempted from the provision that you can't transact business on a Sunday. So that would still be a thing, for lack of a better term, along with applications for protection orders against domestic violence, stalking and harassment, high risk, et cetera. Those are all current statutory exceptions. So this conforms the statute with district court but leaves those alone. So those crucial pieces of business can still be conducted.
Thank you.
Vice Chair Harris.
Thank you, Madam Chair. The way I read Section 1 is more of a restriction on courts, except a justice court or municipal court, not a requirement necessarily that justice courts or municipal courts be open. Can you talk a little bit about why this is necessary to kind of strike the language and change things around it? It seems that the statute really talks about precluding certain courts from being open, not yours, but that doesn't require that you be open.
John McCormick for the record. Honestly, I don't know that I have the best answer for that. Again, it was to conform it with the district court statute, and then I think the idea was the exceptions provided sufficient leeway there. I don't know if Judge Zaragoza has a comment on that.
Hi, this is Judge Zaragoza again. No, I don't have any additional comment to what Mr. McCormick has stated. I think the idea was that it would just be consistent among all of the judiciary instead of having this, odd exception of the justice and municipal courts. But no, I still think the exceptions that are already written in the statute would apply to all, so it wouldn't impact those criminal actions, the criminal proceedings or any action of a magistrate. I would say it's just, yeah, and that would include search warrants as well, because that would also be something within the power of the magistrate.
Right, so my concern, I guess, is not that there would now be certain business that would not be able to be conducted. I guess what I'm trying to get at is it looks like you all could just close on Sundays if you wanted to, and now you are coming to us and asking us to mandate that you be closed on Sundays, otherwise you wouldn't. And I'm not sure why we need a mandate for you to close on Sundays. It just says you could do business. You don't have to. Does that make sense? Am I getting at it here? If you want to close, you can
I think
currently.
that's a fair point, Senator.
Okay, thank you.
Senator Dondero Loop.
Thank you, Madam Chair. As the non-lawyer on the committee who knows just enough to be dangerous sometimes, I'm confused why we need this bill, like why you need to put these particular like pricing in a bill. I was under the impression from years past, I guess, that you could just change those. In other words, as a division, if you decided you needed to charge 50 cents instead of $1 or $1 and $2, does this all have to be in statute? Do we have to have this here? And I don't know who wants to answer
May
that.
I respond? This is Judge Zaragoza. Senator Dondero Loop, the statute, well, there's really two ways in which fees to the court are derived. And quite frankly, one of them is the statute, this 4.060, which has existed for many, many years. And then the second is the court's inherent power to charge certain fees. In this sense, this 4.060, because it has always been in statute since I've been on the bench 15 years, and it was here long before I ever came along. It also talks about the filing fees. It adds in other fees in sections beyond this that help support the Neighborhood Justice Center, the Civil Law Self-Help Center. So we cannot, if the fee is written in this statute, we cannot just change it at any point. I think that was probably to avoid having inconsistent fees charged for filing of a small claims complaint in Las Vegas or Henderson or North Las Vegas or Elko or Ely. So I think that was where the consistency and across the board that the fees should be the same across the state came in. So we don't just change our fees. The last time our fees were increased was in 2013 in a bill, and prior to that, it had been 20 years since the fees had been increased. So for purposes of just clarifying, we kept it within the statute, and that's why it's here. I don't disagree that the redaction probably could be something we would impose just as our inherent power of the judiciary, but because it kind of went along with requesting records and documents from the court, we thought we would include it in the statute. The other portion of this statute is the court's ability to keep a portion of those funds that goes back to the court to support the court system rather than to the general fund. And so that is all part of this.
Thank you very much. And maybe that's why I felt like I did, because 2013 I was on Judiciary, and so I probably heard this bill at that point. I'm looking at your 4.060, and thank you for that clarification.
All right, I think Senator Orenshaw, did you have a question?
Yes, Chair, a brief one. Thank you, and thank you, Mr. McCormick, and Your Honor, thank you for presenting the bill. Whoever would like to take this question, my question has to do with Section 3, the new language on page 5, lines 20 through 23, the $1 fee per page for redaction of personal identifying information. I understand that that's so necessary, and that's an extra burden for the courts and your staff to do that. I just wonder, in terms of whether this will become a barrier for the press or the public who are interested in these public documents, do you have any idea in terms of recent requests from media for these kind of documents, whether we're looking at something that may be, $10, or will it be, $500, or is that just a question that can't answer right now? I just wonder if there's any information. I'm just worried this might become a burden on transparency.
This is Judge Zaragoza. Senator Orenshaw, thank you for the question. I did not ask the question about like the average number of pages a report could be. I will say that one of the longest reports, when I inquired about how many they get a year, and there's about 1,000, just from looking at a case report, I'd say the average report is probably 3 pages long. But, those news media worthy cases are probably more larger, bigger cases. I know that they had a case, the largest one was 45 pages of redaction, so it would have cost the media 45 pages to get a copy of the redacted declaration of a warrant for arrest. I don't think $45 is going to chill any media attention, or, it's not going to chill their impact of getting these documents. It'll just help us defray some costs.
Okay, thank you. That gives me more comfort. Thank you, Your Honor. Thank you, Chair.
Any other questions? Senator Nguyen.
Thank you. I should have asked this before. This is related to Section 4, and I just have a question about that. I see that you are kind of it seems like you're taking the approval of the Board of County Commissioners out of the equation on the appointment of those clerk of the court. It gives some authority if the Justice of the Peace wants to appoint another person. Aren't the clerk of the courts paid by the counties, though?
This Judge Zaragoza, Senator Nguyen, yes, all of our employees are paid by the county, to include the justices themselves. But in practice, the Justice Court hires our own court administrator, and our court administrator is the clerk of the court. That's the way the job description currently is. The county commission, at least in Clark County, has never appointed a clerk of the court or ever appointed a deputy clerk, which is kind of what was contemplated here. So I think for all practical purposes, the way we have drafted the proposed language is the way it is done in practice. And it's my understanding, and John, you may be able to answer it better than me, for our other courts that have more than one justice of the peace, or how they designate their clerk of the court, how that's done in, say, Washoe or some of the rural areas that have more than one justice.
Thank you, John McCormick, for the record. In Reno Justice Court, for example, it's very similar to the way that it's done in Las Vegas Justice Court. And I would point out that subsection 2 of that statute, that the county commission still fixes the compensation. So there is that sort of check and balance there.
Thank you.
All right. Any other questions from members of the committee? Not seeing any. Thank you again for presenting this bill to us and answering all of our questions. We will move now to testimony. We'll start with testimony in support of SB 55. Anybody wishing to give support testimony here in Carson City or in Las Vegas, please go ahead and make your way to the table. And go ahead when you're ready.
Good morning, Chair Scheibel and members of the Senate Judiciary Committee. My name is Jeff Rogan, R-O-G-A-N. I'm testifying today on behalf of Clark County. We are in support of SB 55 as written. I just want to address some question that Senator Nguyen asked with regard to Section 4. Judge Zaragoza is correct. Even though the statute says it's the Board of County Commissioners that is supposed to appoint the deputy clerk of the court, it has consistently been the justices of the peace that select that person. The Board of County Commissioners does establish the salaries and benefits for that position, and depending upon the size of the justice court, so if it's a smaller court or a larger court, those salaries and benefits are different. So in my opinion, nothing changes under Section 4 other than to recognize the status quo, the standard operating procedure that's been in existence in Clark County. And in fact, I think that this is actually more consistent with some recent case law that came out about 10 years ago that establishes that it's the court really that should be selecting its employees and not the Board of County Commissioners. So we are in support of this bill in whole, and if anyone has any further questions about Section 4, I'll be happy to talk to you about it as it regards to Clark County. Thank you.
Thank you, Chair Scheibel, members of the committee. My name is Tom Clark, T-O-M-C-L-A-R-K. I represent the Nevada judges of limited jurisdiction. Judge Zaragoza has done a phenomenal job, but I want you to know that all of the other judges of the association support this bill as well. Thank you.
Thank you. I don't see anybody else coming to the table in Carson City or Las Vegas, so we will go to the phone, please, for testimony in support of SB 55.
Thank you, Chair. If you would like to offer testimony in support of SB 55, please press star 9 now to take your place in the queue. Thank you, Chair. There are no callers wishing to offer testimony in support of SB 55 at this time.
All right, thank you for your help. We will move then to testimony in opposition to SB 55. Anybody wishing to give testimony in person in Carson City or Las Vegas, please make your way to the table and begin whenever you're ready.
Good afternoon, Chair Scheibel and committee members. My name is Nicholas Shepak, S-H-E-P-A-C-K. I am the State Deputy Director of the Fines and Fees Justice Center. So we got a bill with some fees in it. I am here in opposition. We want to thank first Mr. McCormick for always working with us and always reaching out to us and working with all stakeholders to try to get us into the right position. Part of our mission as an organization is to eliminate fees in the criminal legal system. Court and the services that they provide are essential to the functioning of our communities and therefore should be funded through general appropriations, not the backdoor taxes that we often refer to as fees. Members of our communities who have interacted with the criminal legal system need access to court records for many reasons. Many of these individuals are attempting to turn their lives around and become productive members of our society. And barriers of additional fees to access court documents through these search fees that may be a necessary part of the efforts to turn their lives around, that's just is unacceptable to us. If this bill passes with these fees, which we are staunchly opposed to, there needs to be a way for individuals who are of low income to request waivers of these fees. The electronic search fee does not appear to be tied to any real tangible work. And if there are new fees that this body allows, which we do not suggest, we strongly suggest that we know the true cost of the work and make sure that those fees go directly to the work and aren't just kind of plucked out of the air. We share the sentiments of many of the questions that were asked today and are concerned that even at a penny, that fee could become burdensome from some individuals. And again, we thank the bill sponsors for talking to us and are willing to work with us on this, and we hope we can come to a resolution. Thank you very much.
Good afternoon. Thank you, Chair Scheibel, members of the Senate Judiciary. Tanya Brown, spelled Tonjabrow'n, Advocates for the Inmates and the Innocent. We oppose this bill. As an advocate, some of the things that we do, we try to help those who've been wrongfully convicted seek newly discovered evidence through the court records. These could be their petitions, post-convictions, writs. We try to look at their exhibits, and this can cost quite a bit of money. They are indigent. They have no money. We as advocates, we do this for free. It would cost us. We cannot personally afford this, okay? I will say that some of you may not be aware of this, but I can only speak to the Second Judicial and to the Nevada Supreme Court with their caseloads. I can tell you that in the Second Judicial, they have a backlog of about 50,000 cases that have not been scanned into the computers. That information is stored at an off-site facility, which, again, how much is that going to cost? When you look at the defendant's cases, you have the criminal case number. And when you file a petition for post-conviction, it then becomes a civil case. And then there are other cases. There could be several cases tied into one case. And this could get into a great deal of money. So we would also, and as far as the Supreme Court goes, same thing with the Supreme Court. They don't have all of their cases scanned in through the computer system, and it becomes a problem. And if you go down there and try to locate it, they will tell you we don't have it. Unless you actually know the case number, and including in the district court, just Second Judicial, they don't have any record of, they don't know, so that cost is going to go up. So if you come back and you show them the case number, they'll tell you we don't have it. Then the next step for the Supreme Court is to go into the law library, go online, and look at the microfilm and pull it up this way. And then you might be able to find it there. But again, if somebody is looking and they tell you, well, you can go over to the books and look at all the cases, cite the name to run it up. Some of those cases are omitted. They're not even in the law library books, the Supreme Court's decisions. So again, we have an issue with that. Also, like I said, we have
You are reaching 2 minutes. If you could wrap up.
Okay. Thank you. And another thing, too, is we are finding newly discovered evidence in people maintaining innocence who are incarcerated. And so we want to be able to look at these exhibits so we can show that, yes, it is newly discovered evidence. But if you're going to charge this, and what we ask is that we are asking that all fees are waived for the indigent and for the indigent defendants and those searching for court records on their behalf. Thank you.
Thank you so much. I don't see anybody at the table in Las Vegas, so we will go to the phone for testimony in opposition to SB 55.
Thank you, Chair. If you would like to offer testimony in opposition to SB 55, please press star 9 now to take your place in the queue.
Good afternoon. Jim Hoffman, representing Nevada Attorneys for Criminal Justice. We're opposing this. One of the reasons is the reasons that Mr. Shepak gave. We're concerned about these fees for the general public. In particular, there's a lot of people who have evictions going on, and there's a lot of people who have family court cases. These are, not usually very wealthy people. And even if they are wealthy people, $5 per search is still a lot. The other point I wanted to make is that for me as a practicing lawyer, searching in an electronic case management system is something that I do every day, multiple times a day. This morning I went to court. Before I went to court, I searched for my client's name in an electronic case management system to make sure that I had the right courtroom and the right time. After I get off this call, I'm going to search for my client again so that I can pull all of the records and download them from the system. And that's just one client on one day. As most of you know, I assume all of you know, a track prosecutor or a track public defender can have hundreds of cases in a day. So are they going to have to pay $500 for their 100 cases? How does that work? Is the Clark County DA's office going to be paying the justice court? So we think that this fee introduces a lot of questions and problems into the system. And so we're opposed to it. We're opposed to this specific part of the bill. We don't have an opinion on the rest of it, but this fee we're very strongly against. Thank you.
Anne Marie Grant, ANNEMARIEGRANT, advocate for the inmates and the innocent. We are opposed to SB 55. As someone who has put in public records requests across a variety of agencies in Nevada, I can testify that any type of increase in fee is a barrier to the general public, to indigent folks, to myself. So going from 50 cents to $1 may not seem like a lot. That's a 100% increase. I mean, I think that there should be no fines, fees at all for public records. Thank you.
Thank you, Chair. There are no other callers to offer testimony at this time.
All right, thank you. That takes us to neutral testimony on SB 55. Anybody wants to give in-person testimony, now is your chance, but I don't see anybody coming to the table in Las Vegas or Carson City, so we will go back to the phones for neutral testimony on SB 55.
Thank you, Chair. If you would like to offer neutral testimony to SB 55, please press star 9 now to take your place in the queue. Thank you, Chair. There are no callers to offer neutral testimony at this time.
All right, thank you very much. If the presenters would like to give some closing comments, you may, but it is not at all required. And it looks like we don't have any closing comments this afternoon, so we will close the hearing on SB 55. Thank you again for your presentation and answering all of our questions, and we will open the hearing on SB 62.
Thank you, Chair, members of the committee. For the record, John McCormick, Assistant Court Administrator at the Nevada Supreme Court. And Senate Bill 62 is an outgrowth of AB 43 of last session, which asked the Nevada Supreme Court to form a committee to study judicial discipline. And to that end, we formed the commission to study the statutes and rules of the Commission on Judicial Discipline and update the Nevada Code of Judicial Conduct. So that's a mouthful of a commission name, for sure. And you all have an amendment that I sent over because we're treating this as, in the parlance, a gut and replace bill. So I'm going to speak to the amendment that was provided rather than the original text of the bill, which was not, which ended up being sort of a placeholder. But the commission has agreed on the amendatory language, and the amendatory language is intended to leave 1.445, which was the original text, as written, and make a change to 1.440. That change simply clarifies the disciplinary jurisdiction of the state bar and the Commission on Judicial Discipline for attorney judges, indicating that the commission's jurisdiction over the judge starts when they take office, and acts prior to that are still under the purview of the state bar. As the commission discussed this, the Office of Bar Counsel was okay with that, and I believe the Commission on Judicial Discipline as a participant in the committee was okay with that as well. So this is to clarify that sort of jurisdictional question that's been out there for a while.
All right, thank you. Any questions from members of the committee? I don't see any questions, so thank you. And we will move to testimony. Anybody wishing to give testimony in support of SB 62 in person should come to the table now, but I don't see anybody. Let's go ahead and see if there's anybody on the phone in support of SB 62.
If you'd like to speak in support of SB 62, please press star 9 now to take your place in the queue. Thank you, Chair. There are no callers wishing to offer testimony in support of SB 62.
All right, then, we will move to testimony in opposition to SB 62. I don't see anybody coming to the table in Carson City or Las Vegas, so we will once again go to the phones for any testimony in opposition to SB 62.
Provide opposition for SB 62. Please press star 9 now to take your place in the queue. Thank you, Chair. There are no callers to offer opposition testimony at this time.
All right, then, we will go to testimony in the neutral position on SB 62. Come on up, you'll have 2 minutes.
Tanya Brown, TONJA, Advocates for the Inmates and the Innocent. We are in neutral on this. I don't think it's ever been discussed, but I know that I have come across this in the past, and that is where we will just say that if an attorney commits a crime, okay, and you file with and has done some unethical things, you file it with the state bar. The state bar will wait pending the results of the outcome. And so, for example, if you file a police report against the attorney, the state bar will not touch it until that is resolved. But it is turned over to the district attorney's office. The district attorney's office will sit on it until the statute of limitations runs out. So the attorney, there is no repercussions for the attorney who committed the unethical acts or a crime committed to a case. So we're in neutral, but I just wanted to bring it to your attention. It does happen. Attorneys can go and do what they want when they are defending an individual. They will commit perjury to protect their careers. When it is discovered and the police confirm, yes, they have committed the perjury. We agree with you. We're sending it over to the DA's office, and they sit on it until the statute of limitations. There is no resolution. State bar won't do it, and the DA won't do it. Then they can go on and become a sitting judge. Thank you.
Thank you for your testimony. I don't see anybody else to give in-person testimony in neutral, so we will go to the phone lines for neutral testimony on SB 62.
Thank you, Chair. To provide neutral testimony for SB 62, please press star 9 now to take your place in the queue. Thank you, Chair. There are no callers wishing to offer neutral testimony at this time.
All right, then that brings us to the conclusion of our hearing on SB 62. I will now close the hearing and move to the next item on our agenda, public comment. Anybody wishing to give public comment in person can come up to the table now in Las Vegas or Carson City. I don't see anybody, so we are going to go to public comment on the phone lines. Anybody wishing to give public comment will have 2 minutes.
If you would like to offer public comment for today's meeting, please press star 9 now to take your place in the queue.
Anne Marie Grant, for the record, private citizen. 4 residents of Nevada died during interactions on this date, February 23rd, since the year 2000. They include 21-year-old Jamie Padilla, LVMPD, 24-year-old Stephen Valenzuela, Reno PD, 34-year-old David Crams, Reno PD, and 23-year-old Ja'Cory Shaw, who was killed 1 year ago today by Sparks PD. It is not without pain, and it is with a heavy heart that a mother grieves the loss of a son. Ja'Cory meant so much to so many, and although he is no longer with us, he will never be forgotten and live on through the many lives he touched. I stood in solidarity this past September with Ja'Cory's family and other families in Washoe County, requesting Attorney General Aaron Ford conduct independent fact-finding investigations into the deaths at the hands of police that are occurring far too often in this state. The police always get to release the narrative, and it's always a self-serving one. The police narrative about Ja'Cory was as follows. Sparks PD released a canine to detain Ja'Cory. He then pulled out a gun and pointed at detectives and was shot. Body cam footage refutes that narrative. He was completely unarmed when they shot him. Every legal gun owner in Nevada is a walking police narrative. Imagine your son, mother, father, daughter, or friend being murdered. Imagine if the police knew the perpetrator's name but refused to release it. That is exactly what happens in Washoe County, Nevada, when police murder your loved one. Ja'Cory's family, like far too many others, have received zero information, and it's been a year. Ja'Cory's family will gather in Hungry Valley on 2/25 for a celebration of Ja'Cory's love and life, to include a graveside balloon release at 3 p.m. Please pause on that date in time to remember Ja'Cory and to reflect on the far too many community members in Nevada who were tried, convicted, and executed by police since the year 2000, which is 468 human beings. Thank you.
Thank you, Chair. There are no other callers to offer public comment at this time.
All right, then that takes us to the conclusion of public comment and the conclusion of our meeting today. We do not have a meeting tomorrow. I hope everybody gets home or wherever they're going safely. And we will see you on Monday at 1 p.m. Meeting adjourned.